Hello everyone, I am Grace Navakoza and I am the Head of Employment Relations and Legal at the Federation of Uganda Employers. In this video, we are going to be talking about how to be on the safer side of the labor laws of Uganda. In this video, we are going to be speaking of the how. What are some of those key things that you need to have at your workplace as an employer to ensure that we are complying with the employment laws or the labor laws of Uganda. When we talk about the employment laws or labor laws, we are meaning the one and the same thing. But these are the laws that govern labor and employment in Uganda. For instance, one of those key laws that governs the employment and labor sector in Uganda is the Employment Act of 2006. We also have the Labor Disputes Arbitration and Settlement Act of 2006. We also have the Labor Unions Act of 2006, but we also have the Occupational Safety and Health Act of 2006. At the helm of these laws is the Constitution of the Republic of Uganda that gives breath to the existence of these laws of 2006 that we have talked about. Of course, you realize that there are a number of other laws, the NSSF Act, the Pensions Act, that also directly relate to labor and employment in Uganda. But for purposes of today, we will speak about those of 2006. And we'll straight get into what or how you need to ensure that you are on the safe side of these laws that we are talking about. The first thing and the most important thing, let us move away from verbally employing people at our workplaces. It is very important that we formalize the employment relationship by ensuring that each employee has an employment contract. This employment contract has to put down the nature of employment. Is it permanent employment or open-ended contract? Is it a fixed-term contract? Is it a temporary contract? At least in that way, you will know, or the employee will know, that these are the circumstances that govern me. I am in here to work for this period of time and for this particular purpose, other than leaving it vague for interpretation by anyone. So the other thing that you need to know in regard to these employment contracts is that you need to have a comprehensive terms and conditions of service, or what we would call, or what is commonly called, the Human Resource Manual or the Human Resource Policies and Procedures Manual. Now, this manual, besides the employment contract, speaks about broader terms and conditions of service that an employee is going to enjoy or that the employee must observe. For example, code of conduct, disciplinary process, how to handle issues of sexual harassment, how to handle issues of safety and health at work. All those are placed in this manual or in this policy or in these terms and conditions of service without specifically putting it in an employment contract. The other thing is that even if you have drafted it and it is in place, you need to ensure that it is periodically reviewed. You cannot have a document that you developed in 2000 and you think circumstances are still applying 10 years or 20 years from now, since then. So circumstances have changed. And what is very important is that once you have this policy, ensure that periodically, after 3 years, after 5 years, you're able to review and incorporate and change and amend and modify. And again, you need to tell employees that there is existence of this manual. We have seen situations where an employer drafts the policy but keeps it to themselves. This policy is supposed to guide you and your employees in this employment relationship. So do not draft this terms and conditions of service or this manual. Do not keep it to yourself. Once you have made changes, once you have it in place, please disseminate it to the employees. Let them know, let them sign letters of acknowledgement. That way, it will ensure that both parties remain binding to this document, and in case of any litigation, you will always pull it out, because we have also seen situations where employees deny the existence of this manual. So once you have disseminated it to them and you have evidence that you have disseminated, then they can never deny in any situation that this policy does not apply to them. The third is you have to ensure that you consult, because these labor circumstances keep changing all the time. Don't think that the way the law applied in 2000 is the way it is applying even in 2020. No. Circumstances have changed. We now have the industrial code, and it has given clarity on some of those gray areas that we're having in these the laws that I have spoken about. So it is very important that you keep consulting, you keep reading, you keep ensuring that you're learning from best practices from other employers. How are other employers handling situations, for example, of sick leave? How are other employers ensuring that employees safely go on maternity leave? If the workplace is a hazardous workplace, how are your colleagues, how are other employers in the different sectors handling situations like that? So it means that you're not going to keep it to yourself. You are not going to ensure that I am an all-rounder, I understand everything. No. We are here to consult one another. We are here to understand from one another and borrow those good practices. And of course, in that way, we start abandoning the wrong practices which are likely to lead us into litigation. The most important thing again is to ensure that you don't take decisions out of emotions. We have seen so many situations where an employer, because an employee has been absent, because an employee has gone on maternity leave, because she was pregnant or expecting, and the employer all of a sudden says, do not come back, I have terminated you. In situations like that, where you think you're in an argument or there is heat in a particular discussion, you need to just hold back, and in there, you're able to consult and be able to take the right steps or the right direction as an employer. Let us desist or stop taking decisions with emotions. In other words, we need to ensure that our managers, our management teams avoid situations like that, because we have seen when we take decisions out of emotions, there is also exposure and likelihood to litigation. The last item is we need to ensure that we periodically audit our practices and procedures at the workplace. Well, you could have a streamlined policy and procedure. You could have also all employees getting their employment contracts and they're periodically updated. But there are certain practices and procedures that are extremely wrong, that if a reasonable person looked at them, if we are in court, they would say that this practice is actually wrong. Why we advise employers to ensure that they make these audits or periodically carry out these audits is to pick out those gaps, those challenges, and be able to come up with a comprehensive report. You seek guidance, you consult with your legal teams or with your legal representatives, or even with the Federation of Ugandan Employers on how to successfully ensure that these gaps do not reoccur, because we have seen once those gaps exist, then there is likelihood for litigation by the employees against you as an employer. We hope these points, you will put them at the back of your mind, and they will guide you further in terms of ensuring that you are at all times on the safer side of the law. Feel free to get in touch with us at the Federation of Ugandan Employers. We are more than willing to assist you. Thank you very much.